today for sentencing in the state of Ohio versus Chase Noland, case number 23CR305. Defendant is present with counsel, Mary Springer. We were last before you on April 24th, 2023 for an information hearing, and at that time, defendant pled guilty to one count of aggravated possession of drugs in violation of Revised Code Section 292511, a felony of the 5th degree, with a forfeiture specification. A pre-sentence report and drug and alcohol evaluation were ordered and have since been completed, and the defendant has 99 days of jail credit.
How many?
99.
Ms. Springer, any reason not to go forward with sentencing?
No, Your Honor.
Anything you'd like to say on behalf of your client?
Yes, Your Honor. Thank you. Mr. Nolan is requesting the court give him an opportunity for community control and treatments. Mr. Nolan is willing to comply with any treatment that the court would order of him, including NeoCap. Obviously, he has quite a criminal record for just being 24 years old. He has had a lengthy prison sentence, and when released, continued to make poor choices. But Mr. Nolan has indicated to me and has indicated to the probation department that he really would like this opportunity to turn his life around, that this is a turning point for him. He recently lost his brother, who passed away from a drug overdose, and he's concerned that that's going to happen to him as well. So he really wants to try to get better and make himself and his family proud. And he hasn't had some of the tools that he would like in order to be able to make those choices. And he's been given opportunities in the past, but wasn't ready. And he's indicated that sitting in the Lake County Jail for the last 99 days has shown him that he could go back to prison, make those bad choices, and just continue to live the way that he was living. But he'd like to put in the work this time. And so he's asking the court to give him a shot with doing that. Thank you, Your Honor.
Thank you. Mr. Nolan, you have the right to address the court before your sentence. You can say anything you want. Is there anything you want to say at this time?
Yeah, I just want to apologize for my actions, and that even me sitting in the county for this little bit of time, it brought my head back on straight. I went off a bad path, and my brother OD'd, and I could have ended up just like him, and then my dad would have no kids right now, and I'm glad it didn't happen. And on top of that, I got a kid on the way, but I got to focus on myself because, like, her mom came and visited me, and she still kind of trying to be, like, on that, trying to use and stuff, and I don't need that in my life. Even my dad said, hopefully, like, I need to better myself before I can do anything.
I'm confused whether you have a child, expecting a child or not.
Yeah, from what I just got, her mom came visited me about a week ago and said,
Whose mom?
Haley's, which is my baby mama, Haley Gibbs, and
her mother came to visit you?
Yeah, okay. And said that she's trying to go to treatment because she's getting closer to having the due date, and that hopefully everything goes good, but I need to focus on myself. And she said to worry about the kid, but also, like, if the kid, when it comes out, if I'm in treatment and everything else, that she'll take care of everything until I come home, because, like, her daughter's not ready to grow up at the moment, or still kind of using, so they're trying to deal with that. But I'm in here, and her mom really looked at me and told me to focus on myself and get myself better first before I could try to even raise a family and handle that. And that's what I got to do first, too. And my dad told me the same thing. So, but I do have a kid on the way, so it is expected. But either way, I need to focus on myself before I can even try. I can't even take care of myself at the moment I'm out there. So how do I taking care of a child? So I got to better myself first.
Why are you going to do it this time? Because you've been given many chances before in the past, and
I never
did it.
Yeah, I never actually tried the steps or did them. I just did whatever I could to just get back to go smoking weed or do whatever I could again. And then what really did it for me this time was I was really trying to be sober out there all the way up until my brother OD'd, and then me seeing him actually die kind of brought me down to where, like, I was using, and I was with a girl that was using, but then I really kind of stopped. But I was more drinking that time period now because I was trying to focus on I'm the one that had to do the CPR on my brother and hit him with Narcan. And that didn't work. And then that was like a rock bottom for me because I don't want to end up like that. And I just came home. And he came home 6 days after I did and only made it 3 weeks and died. And I don't want to be like that. And then my dad's 10 years sober in AA. And then the whole time I've been in here, he's giving me the tough love because he was there for my bid. And
He was there for what?
he was there for my prison bid like the whole time. But like, you know, if I call now, like, hey, I need comments or something else, he's, bro, call me on your free call and everything else. But I need that tough love, and we've talked about it. And then he finally came around, started visiting, but he was like, try the steps. He was like, I'm 10 years sober for a thing, and if I could like go over the message me and him talk about, he was like, Chase, he's like, a sober life is not maybe the life you want or a fun life, but it's a good life, and you have such a like, so good life to live for and to make everyone proud. And he believed in me. Like, I was just trying to go out there when I was on the street when I first came out. My dad's an electrician, got me in electrician school. Well, I got draped off right again with the wrong crowd, going back to hang out with my like friends. And when I graduated, that's exactly what they did. They took me out of my comfort zone, put me in PA. And I went to a school called Summit Academy, and I graduated out there in Butler, PA. Got me in college. I ended up going to Kent State, coming out here to be back with my friends, and got draped right back off. Ended up right back in prison. Then I come home again, and I'm trying to do everything right. And then I do move. I'm doing my electrician school. That's out this way because my girl is in Menor. But I still go back to Cleveland, get draped back off of my friends, and I'm liking trying to just be out of my comfort zone and just start fresh, because every time I do it my way, I end up right back in here, and it's not good. I'm tired of it.
Is there anything else you want to say?
That's it, Your Honor. I just want to do right by me and try to do right by my family for the first time, for real.
Ms. Springer, anything else for the defense?
Nothing further. Thank you.
Ms. Bell?
Thank you, Your Honor. It's clear that the defendant here has a drug problem, and despite his lengthy juvenile and criminal record, the state doesn't believe that a prison term is appropriate in this case, and rather would be recommending community control with treatment. The state's encouraged that the defendant took responsibility by pleading in this matter, and that he's interested in treatment, and that it seems like his father is a good influence and would be a good guide for him as he tries to tackle his sobriety moving forward. So the state would ask that the defendant be sentenced to community control with treatment, specifically NeoCap. Thank you.
No, when I look at the reports that were done, when you talked to probation, you talked about wanting to go to NeoCap and do whatever you need, and you talked to Dr. Rinsberg, and you don't want to do NeoCap. So I'm confused.
Well, I told him I would do NeoCap. I said I want to do.
You said you didn't.
He took everything like I went wrong. I was trying him to do NeoCap, but I was like, the outcome, I was just talking to Mary Springer about it, would be like Lake House. Because when I got out of prison, they put me in Oriana House. I didn't try to even do the halfway house to help myself. So then I got put right back in to finish my time. Sat at CRC the whole time, got out, and then went right back to just doing me until I landed a school to go to electrician school. And a month later, I was draped right back off, like doing whatever else. When I could have just sat for 6 months and been working, doing everything else the way I was supposed to, but I never got that opportunity. So I was talking to him, like in Cleveland, everyone talks about you go to CBCF, and at CBCF, which is like NeoCap, you get to go to work. So I was trying to ask him if, like, I'll do NeoCap. I want to have a period where I can work and make stability and money for myself, because I have a kid on the way, and I want to be able to, like, do everything right, be able to come home, have my own spot, and not have to, like, try to go back to my dad and not try to do anything. I want to do everything right for, like, as a man for my first time. So I was trying to do that. I don't know if he took it wrong. Like, I didn't want to do it. Like, I was trying to ask him.
Well, he didn't say you didn't. He said you would prefer to do Lake House or IOP rather than NeoCap.
And then they just were explaining to me that I got to do NeoCap first and then come home and then go to Lake House and do it that way. And I said, that's fine. I just didn't. I just want to work. I'm trying to do everything right for once, for real.
This court reviewed the pre-sentence report and investigation, the drug and alcohol evaluation. I considered the particular facts and circumstances of the offense involved, the nature of the offense. I've considered everything that's been said here today by Mr. Nolan himself, Mr. Springer on his behalf, the prosecutor's comments and recommendation. All of this is considered by the court in light of the purposes and principles of felony sentencing, which are set forth in 2911. As for the factors in 2912, factors indicating the conduct is more or less serious. Excuse me. There's nothing present factually that would indicate the conduct is any more or less serious than what we normally see this F5 possession charge. As for recidivism factors, many of these are present, however. Defendant committed this offense while he was on post-release control, having just been released from prison a few months earlier. He has a history, extensive history of juvenile delinquency adjudications going back to 2013. Really lengthy record there in juvenile. And he also has a record as an adult. He has a burglary conviction in which he was sentenced to 4 years in prison, right around the time, I think 19 years old at the time, 19 or 20. He has a history of not complying with previously imposed sanctions ordered by courts and parole authority. He was placed on parole when he first got out of prison, violated and sent back. Got a warrant out for him now out of Ravenna Municipal Court for a felony theft-related charge, RSP, and identity fraud. He's had many opportunities to get treatment, and he just leaves after. The last time I think he left after a couple of days in the CATS program. He was there for 2 days and left. No factors indicate recidivism is less likely. Under 2913B1, the defendant again previously served a prison term and he was on post-release control at the time he committed the offense. Those are both factors that override the presumption for probation, permit the court to impose a prison sentence. The court believes prison is consistent with the purposes and principles of sentencing when you consider the defendant's history here. And look at Dr. Rinsberg's report and his prognosis, it's poor. Mr. Nolan, I'll give you one opportunity, and it's only going to be one chance. Don't think that you're going to get multiple probation violations, and there's people there in jail that have violated before, and they get multiple probation violations. This is your one chance, and that's it. I'll put you on community control sanctions for a period of 2 years, finding that you are amenable to an available community control sanction. I will order that you serve 150 days in jail. You have credit for 99 that you've served. I'm going to order that you, as soon as a bed becomes available at NeoCap, that you be released from the jail, enter that program and successfully complete that program following all their aftercare recommendations. The balance of the 150-day sentence will be vacated. So that should be more than enough time to get you in the NeoCap. Again, I don't know, it doesn't seem like it's that long of a wait. It's probably within 30 days, right? But as soon as that bed's available, you can be released to go there. Again, you need to successfully complete that program, follow their recommendations. After completion of NeoCap, I will order at this time, you probably won't have to do this, but I'm going to order that you return to the jail for 30 days to be in the transitional day reporting program. Now, again, you're probably not going to have to do this. Well, I don't know. We'll see. But with the transitional day reporting program, it's a program that helps people who've been locked up to make that transition from being locked up to being on their own. Many people don't have anywhere to go. They have nowhere to live. They don't have work set up. They just, the doors are open. They say you're free to go, and they don't know, they have nothing to do. And this helps them make that transition. Now, if you find yourself in a position where you need that help, this will be there for you. But if you have housing lined up, if you have work lined up, and those are things you can work on when you're at NeoCap, get that set up, then I'll vacate those 30 days. You won't have to do them. But it is a good program for those that need that assistance. So I'm going to put it in place in case, again, you find yourself in that position. The other conditions of probation will be you're not to use any drugs or alcohol. That includes not even marijuana. Positive marijuana screen is going to result in a violation or anything else, obviously. Submit random urine screens. They have to be negative. A positive screen is a violation. You can't tamper with the urine sample, bring in fake urine, someone else's urine, anything like that. You're to attend 3 AA meetings a week and have a sponsor. Now, I want you to obtain mental health counseling to help deal, maybe grief counseling, but help deal with your brother and what happened there. To obtain and maintain full-time employment or school. If you want to go back to school, you can do that as well, but on a full-time basis, you're either going to school or some type of training or working or some combination of both that keeps you busy, 40 hours a week. Do you have a question?
I said yes, sir.
Okay. Take any and all medications as prescribed. Pay your court costs and supervision fees. I'll order the forfeiture of the contraband and instrumentalities. You're not to have any contact with Haley Gibbs for now. Anything else that we should be considering here?
No, Your Honor, I think that's it.
So, Mr. Nolan, you understand all the conditions of your probation?
Yes, sir. Is that for my whole probation? I'm saying with the Haley Gibbs part, I'm not trying to say that I just want to see what's up with my kid. Like, I might not be with her no more. We ain't talked for like 60 days besides on the one phone call type thing.
If
I just want
you're going to need to establish whatever parental rights you have through juvenile court.
Okay.
And if juvenile court grants you, orders you an opportunity to visit or have custody or whatever it is, and you're going to have contact with her as a result of that's all right, because juvenile court will dictate that in terms of visitation, and if that permits you to have contact with her, I'm not going to prevent you from having that contact because of my order. Does that make sense?
Yeah, I already don't want to. I'm saying.
Well, I'm saying you're not going to have contact with her for now. You're telling me she's still using.
Yeah, I don't want
and
that
she
either.
was the one that caused this to happen. You're not having contact with her. Now, you know what? Down the road, if you're doing well and we get reports that she's doing well and you want to revisit that, we can, but it's going to be down the road.
Yes, sir.
So.
And the AA meetings, am I able to do NA meetings
Yeah,
instead?
AA or NA.
Okay.
All right, Jennifer, was there anything else? I'm sorry. You have any other questions?
That was it. I was just with Haley, I already know not to be around her because I'm not trying to go back to using. So.
When I say no contact, it's no contact. That doesn't mean just personal contact. It means you're not to be texting her, emailing her, social media messaging. You're not to have anyone else have contact with her for you. Anything like that is a violation of your probation. You understand that?
All right. When I do end up getting released out, all of my belongings are at her mom's house on Primrose right there and thing. Should I have like an officer or someone come with me to go grab her
Probably
stuff?
wouldn't be a bad idea.
I'm asking you this one. I don't want to do everything right for real. I'm not trying to do anything
Yeah, I mean,
wrong.
if she's not there, then you can go over there.
Or hopefully her mom said if I do get treatment, she'll be able to drop my clothes off at the
Yeah.
treatment program. If not, I did talk to the NeoCap lady.
It's probably a good idea to see if an officer will go with you over there when there's a no contact order.
Okay.
If not to have any contact with her.
That's fine.
All right, well, I need to advise you if you fail to comply with any of these conditions, any of the rules of probation, if you leave Ohio without permission from the court, or if you commit another crime while on probation. Oh, yeah, and I want him to resolve that Portage County warrant. So you resolve that however you resolve that. If that results in any type of conviction, that's not going to violate your probation here.
Okay.
So you resolve that however you think's in your best interest.
It makes no sense to me.
I don't want to. You shouldn't talk about it.
Go
All
ahead.
right. I know nothing about the case, and for your own protection, you shouldn't talk about the case.
Okay.
But you need to resolve it. You need to get that. I can't have you on probation with a felony warrant out for you. So however that gets resolved, you get that resolved.
When I talked to the NeoCap lady that came and met me, she said we'd be able to do something about that while I'm at NeoCap. So.
They usually can help with that.
Okay.
They can help you make arrangements to get it resolved. They can't help you.
No, not like
Deal with it, but-
not just make
Yeah.
it go away. But she said we could handle
Right.
it while I was there. So.
But again, if you commit a new crime while you're on probation, that means a new act from this day forward, not the past. If anything like that happens, a motion to terminate your probation will be filed. If it's found that you violated, I could extend your probation up to 5 years. I can impose more restrictive sanctions against you, including more jail time. Or I could terminate your probation and send you to prison. That's what's going to happen. It'll be 12 months in prison. So that's what's hanging over your head. You understand that?
Yes, sir. Yes, Your Honor.
All right. Ms. Bell, anything else for the record?
Nothing further. Thank you, Your Honor.
Ms. Springer?
Nothing further. Thank you.
All rise.
We are here today for sentencing in the state of Ohio versus Lenny Kirby, case number 23 CR 246. Defendant is present with counsel Mary Springer. We were last before you on April 24th, 2023 for an information hearing. At that time, defendant pled guilty to one count of aggravated possession of drugs in violation of Revised Code 29-2511, a felony of the third degree with a forfeiture specification. A pre-sentence report and drug and alcohol evaluation were ordered and have since been completed. The defendant has 74 days of jail credit. Thank you.
Ms. Springer, any reason not to go forward with sentencing?
No, Your Honor.
Anything you want to say on behalf of your client?
Yes, Your Honor. Thank you. Mr. Kirby is asking the court to give him an opportunity for community control sanctions in this case. Mr. Kirby obviously has an adult criminal record here that includes a lot of his substance use issues, and he has continued to struggle with that substance use, and unfortunately has led to him being in front of this court. And Mr. Kirby has, or did while he was on bond, attempt to address some of those issues. He was able to go to Salvation Army in Erie, Pennsylvania for a period of time. And then after he was no longer in that facility, he enrolled in an IOP at Brightview. He understands that that wasn't what he was permitted to do while he was on bond, and that he did that there was a problem with that. But some of the good things that I can say is that Mr. Kirby was able to continue to maintain his abstinence. He did not relapse. He continued to remain sober while he was out on bond, and was doing things that he felt were very important to him, such as going to school. He wants to one day be able to help people that are in a similar position with struggling with substance use. And I will say Mr. Kirby, I think, was very proud of himself in a lot of ways. And I think some of his family was proud of him as well. And he has a lot of support here in the courtroom. And all of them are here to support him no matter the outcome of what happens today. And Mr. Kirby is willing to do any sort of treatment that the court would give him. I know he has had opportunities to do that before, and he wants to get better, and that's what he's hoping the court will consider today. Thank you.
Thank you.
Sorry, I also did just provide the court today an affidavit of indigency related to Mr. Kirby's indigency with the mandatory fine. We would ask that fine be waived for the felony of the third degree. Thank you.
We'll make sure you file this after this hearing.
Yes, Your Honor. Absolutely. Thank you.
This is the original you want to file?
That is, yep.
Thank
You, Your Honor.
You're welcome. Mr. Kirby, you have the right to address the court before your sentence. You can say anything you want. Is there anything you want to say at this time?
Yes, sir. I was sober for almost about 2 years. Being released from prison, Salvation Army, or the Harbor Lights facility, I was able to stay sober, and I lost my father and 2 brothers, and it took a toll on me. And I know it's not wrong. I know I don't want to put my blame on anybody. It was all my fault. I struggled. I relapsed. I really was trying. I would volunteer my time with the veterans on my days off. I would go with the veterans and go help with the food pantry. and just volunteer my extra time to give back to the community from what I've taken from it. I put myself in school. Took out a loan for college for my chemical dependency license. I want to help another addict. I didn't forget the stuff that they taught me in those rooms. I believe, the death of my brothers and my father, it kind of opened my eyes to, it could have been me. And I relapsed.
What do you mean it could have been you?
It could have been me. It was during COVID and stuff like that, and I wasn't able to say goodbye.
You didn't talk to either of them in years.
I talked to one of my brothers and my other brother. I talked to both of my brothers. My dad, I didn't talk to.
I'm just reading the pre-sentence report. It says defendant reported he hadn't spoken with his father in over 6 years leading up to his death. In regards to Logan, who passed away in August, the defendant reported he has not spoken to his brother in years prior to his passing.
It was the other brother that I haven't talked to in years. That'd be Robert Murray.
There's not even another brother listed in the pre-sentence report.
That's my stepbrother.
Sorry?
That was my stepbrother.
Who was?
Robert Murray. I lost him just leaving when I just left prison. And
who's Logan Kirby? He
Logan
passed away in August of 21.
That's my brother. That's my full brother.
And there's not even a Robert in the PSR.
That's my stepbrother. It's just and my kids. I have 3 children, and I haven't seen them in 10 years. Due to my drug use and stuff, I don't want them to see me messed up on drugs. I was sober for 2 years, and I still wasn't able to talk to my kids, and that took a lot of toll on me too. And I just gave up, and I got back on the path. I knew it was not the right thing to do, and my family was there to support me through the whole 2 years I was sober, and it was a great life. It's just in my head, I have mental problems, depression and anxiety, and panic disorder. And I believe I was doing pretty good. I mean, for since the last bunch of years, since 2010, I've struggled with my ex. I had a divorce, and right now I'm doing this for myself. And I got myself into college, and I surprised myself. And I wanted one day. I like helping people. I screwed up and I hurt myself, and I take responsibilities for that. And I am at the mercy of your courtroom today. And I really want to get better. And Alpha House, I called Alpha House, and they said that they will allow me to study for chemical dependency, and they will help me, and they'll hire me in their facility, and it's a lengthy program.
They're going to hire you, they said?
They said they would hire me in there.
Just like that? They're going to hire you?
No. I would study for the chemical dependency, and this would be like over a year program.
Right, and then but as soon as you graduate, they've already said they'll hire you.
I talked to the lady there, and she says, well, we'll help you. We've actually had people actually get hired in our facilities, and they encouraged that, and they encouraged me going to college and stuff like that, and they live right up the street from my sister, and she's the one who actually told me about the program. And when I went to IOP and I got there, I was awaiting a bed in Alpha House. I was trying to get in their program, and ever since when I left the Salvation Army, and I called them, and they said, and that's when they told me all this stuff, and I'm like, well, it sounds like a really good program, and they have a bed waiting for me. They said they're waiting on your decision if I can attend their program. And
Speaking of Salvation Army, we've gotten like 2 different stories as to what happened there. You've told a couple different stories about that.
the Salvation
Did you
Army.
get kicked out because you had a cell phone, or did you leave because you couldn't have a computer to study there? We've heard both versions.
This was well, it's kind of both of them.
You don't get kicked out, or you don't voluntarily leave.
Well, they
It's
told me
two
they told me I could come
diametrically
back.
opposite things.
They could told me I could come back the following Monday, but I wasn't treated right there. They weren't treating me right in the fact of they like labeled me like autistic, and they would make fun of me. because I was different. And I just didn't feel it. So I wanted to get my chemical dependency license and stuff. They said, well, you're not going to be able to study anything here. Yes, I did get caught with a phone, but the phone was, as soon as I left that day, I went out and I tried to get, I was allowed out. So I went and got a cell phone, and this was like almost 30 days after I was there. I was allowed to have my phone after 30 days. And the day before, yes, I messed up and I took it upstairs, and the guy called me on the phone and I gave it to him. And he says, well, you're not allowed to have a phone here. If he says, you're not allowed to have a phone upstairs. I said, okay, I apologize. He says, you can stay. And I said, well, I don't feel like I'm being treated right here. And that's when I was trying, and I started to get, and then he made me leave, and he said, you can come back on Monday. And when I left there, I had I left. It was on a Friday. It was on Easter, before Easter Sunday. And I went to my aunt's house that night, and I helped her out and stuff. And I called the Alpha House, and I tried to get into there, and they said there was a waiting list. So I called Brightview, and I got a drug assessment done, a mental health assessment done, and I got put in the IOP there. And while I was waiting a bed for the Alpha House, I got drug screens. I brought all drug screens. I was drug screened every week. I was out for 2 weeks, and during that 2 weeks, I stayed working full time, and I went over and volunteered for the veterans on my day off, and I stayed clean, and I surprised myself. I got back on track, and I got into college, and I'm trying to do something for the future. Maybe if I graduate there and I get my chemical dependency license, like I could stay into treatment, just make it my whole life. This is something that I need to do and stop all this, life of crime and drugs and trying to hide the fact that I can't talk to my kids. Well, that's my fault. I screwed that up. And one day I'll pay for that. And I've been paying for it my whole life. Maybe they'll come around when they see me better. And maybe when I got my working as a chemical dependency officer, helping people out, and they're going to look at me different when I meet them. And that's what I want. I don't want to go to prison. I don't think that's going to help me, but, I messed up. And right now I'm in the mercy of your courtroom. I wish I can just give me one chance on probation and let me show you I can do this. Yeah, that's what I really want. I want to get better. I don't want it, like my family, like they're all there. I have a support group, and they were there, and that's the only reason why I was able to stay sober that 2 years. And I called them every day, and I go over there and I help my mom, and I help my sister, and I help my aunt all the time. And they've been there, and they're here to help me. And I was in a bad place when I started all this, a real bad place. And now, as I'm doing this for myself now, I know my kids will come around later. And I took that, they ate at me for years. And that's what a lot of these charges from before came from. Because I was trying to do to support, trying to say to my ex-wife or my kids, say, hey, I don't want to do it for those guys. No, it's not that. They'll come around later. And when they come around, I'm going to be better. I'm going to be sober.
Thank you. Ms. Springer, is there anything else?
No, Your Honor, thank you.
Ms. Bell for the state of Ohio.
Thank you, Your Honor. Taking into account the defendant's lengthy criminal record, his prior prison terms, and the fact that he's been offered multiple opportunities for treatment, the state really has no option but to recommend prison here today. Thank you.
Score review the pre-sentence report and investigation, the drug and alcohol evaluation. Consider the particular facts and circumstances of the offense involved, the nature of the offense. I received several letters from family members in support of the defendant. I've read all of those and considered those. I've considered what's been said here today by Mr. Kirby himself, Ms. Springer on his behalf, the prosecutor's recommendation. All of this is considered by the court in light of the purposes and principles of felony sentencing, which are set forth in 2911 of the revised code. As for the factors in 29, 29, 12. Give me 1 second here. Considering the factors in 29, 29, 12, there's nothing that stands out factually about the case indicating it's more or less serious. Obviously, there was more methamphetamine than normal, but it's an F3, which is reflected in the charge itself. So there's nothing more about the facts about the case that makes it a more serious F3 than what we normally see for an F3. As for recidivism factors, that's where the problem lies here. All of these are present in this case, indicating recidivism is more likely. Defendant has a lengthy history, criminal convictions, as well as juvenile delinquency adjudications, goes back 21 years. So pretty much when he became an adult, well, it doesn't have juvenile delinquency adjudication. I strike that. I meant just the adult convictions. He did have some incident in Ashtabula County as a minor, but one incident. But starting in 2002 and going forward, it's just been offense after offense. And then he's been given multiple opportunities here in the Lake County Common Pleas Court before Judge Collins, with Judge Lucci. He was on probation with Judge Collins, and he had multiple opportunities. He would violate, Judge Collins would continue him, give him treatment. He's been involved in every treatment program we have here in Lake County. Every resource or facility we basically have, he's pretty much been to and done. Went to prison finally for violating. So, pursuant to the factors, he's not complied with previously imposed sanctions ordered by courts, which is a factor, again, indicating recidivism is more likely. He has served prison terms, got out, and then looks like just within a few months of getting out, picked up another charge out of looks like Ashtabula County, I believe, which is still pending right now. Issued for him in February out of Ashtabula for a new forgery charge. Other conditions indicating, well, he's obviously got a drug problem that relates to the offense, and no matter what efforts have been made here, he just continues using. Other relevant factors indicating recidivism is more likely. Defendant was on bond. He was given an opportunity to go to a treatment facility as a condition of his bond, and he left. Didn't tell anybody. He decided that he was going to, I guess, set his own conditions of bond and do what he felt was what he should do instead of following the court order as to what was required. He was given a bond with specific conditions. You don't get to choose the conditions that you're going to follow and change them because what suits you better. That's not how it works, but that's what you did here. Didn't tell anybody until we were here in court. So you couldn't even comply with the conditions of his bond in this case. No factors indicate recidivism is less likely. Under 2929 13b1, again, the court finds the defendant has previously served a prison term. Prison is certainly consistent with the purposes and principles of sentencing. There's just no way when you look at the history here in the past, and even with this case, that the court can make the finding that's necessary. Two findings. One, the finding is amenable to available community control sanctions, but there's also a presumption for prison in this case. And there's just no way the court can make the findings that are necessary to overcome the presumption for prison. I can't make a finding that the factors indicating he's less likely to commit crime in the future outweigh the factors indicating he's more likely, and that's impossible. Therefore, it will be the sentence of this court that the defendant serve a term in prison of 18 months. He has credit for 74 days he's already served. I need to advise you upon your release from prison, you may be put on post-release control for up to 2 years. If you violate any of the conditions of your post-release control, the parole authority could send you back to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of the prison term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. There's a mandatory fine of $5,000 that's required to be imposed, but I will accept the affidavit of indigency, assuming that gets filed here before the sentencing entry, and I waive that fine. I'll order the forfeiture of any contraband or instrumentalities that are in the specification, in order to defendant to pay all costs incurred in this action. Is there anything else for the record, Ms. Bell?
Nothing further, Your Honor. Thank you.
Ms. Springer?
Nothing further.
All right. If it please the court, we are here in the matter of the state of Ohio versus Ryan W. Nelson, case number 23CR283. The defendant is present in the courtroom, his attorney, Mary Springer. We're before the court this morning for purposes of a plea by way of information in this matter, Your Honor. And I would like to explain that we have 2 counts in this information. And those 2 counts in this information, Your Honor, include a bind-over charge that came from this case, 23CR283. Also, there is a separate case that was bound over, 23CR527. That's a 1-count case as well. So what we've done by agreement here is we've included the counts from both of those cases, and we've incorporated into them one information here in this case, Your Honor.
Then you're going to nollie that case?
Yes, Your Honor.
Okay.
If it please the court, I'd put the terms of the agreement on the record.
Please.
Thank you, Your Honor. As I stated, Your Honor, the defendant is going to plead guilty by way of information in this case to 2 counts. Count 1 being F5, aggravated possession of drugs, that's methamphetamine, felony of the 5th degree. Count 2, possession of a fentanyl-related compound, felony of the 5th degree, for the 2 case numbers that I mentioned. Pursuant to the agreement, the defendant would agree to voluntarily forfeit all items that were seized by law enforcement in both of these cases. The state will review the pre-sentence report, any sentencing-related documents prior to making its sentencing recommendation. The state could recommend any available sentence, including prison up to the maximum on both of these, Your Honor, consecutive. The defendant does not have to agree with whatever the state's recommendation is. I expect that the defendant's going to be advocating for community control sanctions. At some point, Your Honor, if there's community control, the state's going to recommend the defendant have no contact with Arby's. That's
The restaurant?
Yeah. Right over here, Your Honor, in 3 West Erie Street. I just want to put that on the record. State would reserve the right to rescind or modify the terms of the agreement should the defendant violate a bond condition or be arrested for or charged with any additional offense while this matter is pending and prior to sentencing.
Okay.
Thank you.
Ms. Springer, does that all sound accurate?
Yes, it does, Your Honor.
And Mr. Nelson, were you able to hear what the prosecutor just had to say regarding what he believes your intentions are here this morning?
Yes, Your Honor.
It was indicated to the court by the prosecutor he believes it's your intention to waive your right to have this case presented to a grand jury, and I'll explain that in more detail here in a moment what that means, and to go ahead and plead guilty to the 2 charges that are set forth in this information, which I will also go over with you to make sure you understand them. We would then defer or continue the sentencing to a later day to get some evaluations completed, come back on a later day for the sentencing hearing where there's no agreement between the parties ahead of time regarding any recommendations for sentencing. Each side's free to recommend to the court whatever sentence they believe is the right thing to do. Is that your understanding of the discussions that took place between your lawyer and the prosecutor, more importantly, what you want to do here today?
Yes, Your Honor.
Well, before I can accept your plea, I need to make sure you understand everything going on here. I need to make sure you understand what it is you're charged with and pleading guilty to, the rights you have and the rights you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine those issues, I will ask you a series of questions. Now, if at any point when I'm asking you these questions, if you're unsure, unclear of anything I'm asking you, if you need anything repeated or clarified, if you'd like a moment to talk with your lawyer so you could ask her questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right?
Yes, Your Honor.
All right. All right, well, let's get started then. How old are you, sir?
I'm 37 years old.
Are you able to read and write the English language?
Yes, Your Honor.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Now, before you came into court here this morning, have you any drugs or alcohol of any kind?
No, Your Honor.
What about in the last 48 hours?
No, Your Honor.
Not even prescribed medication, nothing?
Yeah, I have prescribed medication, yes. I'm on Remron.
Hang on one second.
Oh, I'm sorry.
That's all right. Oh, it's in here. Go ahead and tell me.
I'm on Remron, Culotta, Vistarol, and I'm on Motrin 800s.
Okay. And when's the last time you would have had these medications all within the last 48 hours?
Yes, Your Honor.
Okay. Do any of these medications affect your ability to understand or appreciate where you are, what's going on, or to communicate or anything like that?
No, Your Honor.
So you're not under the influence of any of these medications right now, which is negatively impacting your ability to appreciate your surroundings?
No, Your Honor.
All right. All right. Now, you should have did you receive a copy of the information that was filed in this case setting forth the 2 charges that the prosecutor mentioned earlier?
Yes, Your Honor.
And at some point you had a chance to look those over?
Yes, Your Honor.
Now, in that information, again, there are 2 charges. And count 1, what's alleged here and what you'll be admitting to is on or about January 12th, 2023, here in Paynesville, Lake County, Ohio, that you did knowingly obtain, possess, or use methamphetamine or some compound mixture, preparation, or substance containing methamphetamine. It's a Schedule II controlled substance. Excuse me. That conduct constitutes the offense of aggravated possession of drugs. It's a felony of the 5th degree. Do you understand what you're charged with in pleading guilty to in regards to count 1 here?
Yes, Your Honor.
Any questions about it?
No, Your Honor.
Now on count 2, which is the other case that basically got merged with this case, or included in this case, I should say, it's alleged on a different day, March 2nd, 2023, in Perry Township, Lake County, Ohio, that you did knowingly obtain, possess, or use a fentanyl-related compound or a mixture, preparation, or substance containing a fentanyl-related compound, and heroin.
The reason why the language of that count is that way, Your Honor, is because looking at the fentanyl-related compound statute, when you have fentanyl itself that is mixed with a Schedule I or a Schedule II controlled substance, that compound itself is called a fentanyl-related compound. So that's why both of those substances are contained in the language of count 2 there.
Okay. And also included in there was heroin, which is a Schedule I controlled substance. So that conduct constitutes the offense of possession of a fentanyl-related compound. It's a felony of the 5th degree. Do you understand what you're charged with in pleading guilty to in that count?
Yes, Your Honor.
Any questions about it?
No, Your Honor.
Well, then before I can accept your guilty plea to these 2 charges, I need to make sure you understand all the rights you're giving up by pleading guilty. And you, first of all, do have the right to have this case presented to a grand jury. So that document that I just read to you is called an information. And what an information is, it's a charge or charges that are brought by the prosecutor's office without this case having previously been reviewed or considered by a grand jury. Now, what a grand jury is, it's made up of a group of citizens here from Lake County that get together and they meet privately. They meet in secret for the purpose of evaluating evidence in cases to determine whether probable cause exists that someone committed a crime. Probable cause is defined as some evidence that would suggest a person probably committed a criminal offense. Now, everybody in the state of Ohio here accused of a felony has the right to have a grand jury independently review the evidence in a case and make a decision without the government being involved in that decision, whether someone should be charged or not. You have that right as well. But you can give up that right if you desire and go forward on the charges brought by the prosecutor in this information, and your attorney has indicated she believes that's how you want to proceed. Is that correct?
Yes, Your Honor.
Well, before I can go any further, I need to have you acknowledge that here in open court in writing, and I have in my possession at this time a 1-page document. It's called a waiver of indictment, which sets forth what I've just explained to you about the grand jury process and that you want to give up that right. Before I can go any further, I need to be assured you understand what's in this document, that you've signed it here in open court. Now, my understanding is that before I came in here, you had a chance to review this with your lawyer. Is that correct?
Yes, Your Honor.
Ms. Springer, is that accurate? Did you review this and read it to your client?
Yes, I did, Your Honor.
Did he indicate an understanding of it to you?
Yes.
Is that correct, Mr. Nelson?
Yes, Your Honor.
Understand what it says?
Yes, Your
Any
Honor.
questions for me about it?
No, Your Honor. My attorney explained it pretty well for me.
Okay. Now, it appears that you signed this document on a line that has your name typed under it. Did you, in fact, sign it?
Yes, Your Honor.
And Ms. Springer, you witnessed that?
Yes, Your Honor.
Mr. DePiro, you as well?
Yes, Your Honor.
All right, I'll make this document part of the record. At this point, I'm going to review with you all the other rights you have that you're giving up by pleading guilty. And you, first of all, have the right to have a trial. Give me 1 second. right. Now, as I said, first of all, you have a right to have a trial. A trial could be me as a judge, or I listen to the evidence and I make that ultimate decision whether you're guilty or not guilty of the charges. But you also have a constitutional right to have a jury trial. And a jury trial would be in front of 12 citizens here from Lake County who would listen to all the information each side wanted to present. The jurors would consider and weigh all that evidence, and then those 12 jurors would make that ultimate decision. And that ultimate decision reached by those 12 jurors would have to be a unanimous decision. What that means is all 12 jurors would have to agree together, one way or the other, whether you're guilty or not guilty of each separate charge. You understand that?
Yes, Your Honor.
Do you understand by pleading guilty or giving up your right to have a trial and a jury trial in this case?
Yes, Your Honor.
Now, if we did have a trial, the prosecutor here would be representing the state of Ohio, and he would have what we refer to as the burden of proof. Now, by him having the burden of proof, what that actually means, it's his job, or he bears the responsibility or the obligation. He bears the burden of proving you guilty before you could ever be found guilty. You are presumed innocent of the charges, and the presumption of innocence sticks with you and remains with you until the state, if at all, was ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes, Your Honor.
Now, when I speak of this burden of proof, since it's a criminal case we're dealing with, the burden of proof is what we refer to as proof beyond a reasonable doubt. And that is the highest burden we have in our justice system. What it actually means, it's the amount of the evidence and the quality of the evidence the state has presented at trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of those charges I read to you beyond any reasonable doubt before you could ever be found guilty of any of those charges. Do you understand that?
Yes, Your Honor.
Do you understand by pleading guilty you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt?
Yes, Your Honor.
Now, in order to do that, or at least in order to try to do that, if we're going to have a trial, the prosecutor would be calling witnesses to come into court to testify for the state by answering questions from the prosecutor. Now, once those witnesses answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same person's questions. That's called cross-examination. So she could ask them anything she wanted to, but within certain rules. Do you understand that?
Yes, Your Honor.
You understand by pleading guilty, you're giving up your right to cross-examine or confront these witnesses that would come in here and testify against you?
Yes, Your Honor.
Now, you'd also have the right at a trial. You could call your own witnesses to come to court and testify for you if you wanted to and answer your lawyer's questions. Now, you're not required to do that, but you have the right to do that if you want to. Do you understand that?
Yes, Your Honor.
And you further can request the court issue an order. We call that order a subpoena. What a subpoena would actually do is it would force or make someone come to court and testify for you and answer your lawyer's questions if they were not willing to do so voluntarily. Do you understand that?
Yes, Your Honor.
Do you realize you're giving up that right?
Yes, Your Honor.
Now, you'd also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That's a decision or a choice that you would have to make. Do you understand that?
Yes, Your Honor.
And since that's your choice, what that really means then is that nobody else could force you or make you. Nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify. But more importantly, the prosecutor here, he's not allowed to call you as a witness and make you get up on the stand and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes, Your Honor.
Further understand that if we did go to trial and you were found guilty, you would have the right to appeal or challenge that guilty finding to a higher court, a court that's above me.
Yeah.
By pleading guilty here today, you are giving up or waiving any right you have to appeal a guilty finding. This court will enter if your plea is accepted, as well as any other issues you could have raised or brought to my attention up to this time. Do you understand that?
Yes, Your Honor.
Do you understand all these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. You understand all those rights?
Yes, Your Honor.
Any questions for me about them?
No, Your Honor. I think you've explained them very well, and I understand everything that you've put forth, and I agree with everything that you've said so far.
And do you still want to plead guilty?
Yes, Your Honor.
Now, do you understand a guilty plea is a complete admission of guilt, so it means you're admitting to the facts being alleged by the prosecutor regarding both of these incidents. We're not going to argue later on, at the time of sentencing or with the probation department or anything, that you didn't do it or it's someone else's fault or anything like that. Do you understand that?
Yes, Your Honor.
Further, as a result of pleading guilty, the effect of that guilty plea is that you'll be found guilty by the court, and then you'll subsequently, on another day, be sentenced by the court. Do you understand that?
Yes, Your Honor.
Now, as far as sentencing goes, you are pleading guilty to 2 felonies of the 5th degree. Each of these felonies of the 5th degree, each of these charges are punishable by a possible term in prison of a minimum of 6 months, a maximum of 12 months, or any whole number in that range of 6 to 12. Do you understand that?
Yes, Your Honor.
Now, since there are 2 separate charges here from 2 separate incidents, if I did impose a prison term on each count, as the judge, I have the discretion to run those sentences either concurrent with each other or consecutive to each other. So concurrent means you'd serve them together at the same time. Even though they're separate incidents, you'd serve at the same time. Whereas consecutive means you'd serve one after the other. You'd serve whatever the prison term was for count 1 first, finish that, then serve the prison term on the second count. Do you understand the difference there?
Yes, Your Honor.
So in this case, if I did impose the maximum sentence on each count and ran them consecutive, you're looking at a maximum possible prison term in this case of 2 years or 24 months. Do you understand that?
Yes, Your Honor.
Now, were you on post-release control at the time this happened?
No.
Were you on probation anywhere?
No.
You have any other criminal charges pending against you anywhere else?
No.
If a prison term were imposed in this case upon your release from prison, you could be placed on post-release control for this case for up to 2 years. What post-release control is, it's a period of supervision you would be on after you served and completed the prison term. And again, in this particular case, it could be up to 2 years. Do you understand that?
Yes, Your Honor.
And if you were on post-release control, we call it PRC, and you were violating the conditions of your supervision, the parole authority could send you back to prison as punishment for violating the rules for another 9 months for each separate parole violation you committed, up to an overall total of 50% or half of whatever the original prison term was imposed by this court. Do you understand that?
Yes, Your Honor.
Now, in addition to the possible prison terms I just mentioned, there's other sanctions that could be ordered. You could be fined in this case. Each count carries with it a possible fine of up to $2,500, so there's a total maximum possible fine here of $5,000. You could also be ordered to pay court costs. You could also be ordered to reimburse the county for any cost of confinement, community supervision, or treatment if that were applicable. Do you understand that?
Yes, Your Honor.
There's also a possible driver's license suspension for each of these counts, up to 5 years. Do you understand that?
Yes, Your Honor.
Now, a few moments ago, I explained the possible prison sentence you face. I did use the word possible because prison is not mandatory. Either of these counts. You are eligible for probation, or what we refer to as community control sanctions. Do you understand that?
Yes, Your Honor.
You understand that just because you're eligible doesn't mean you're automatically be put on probation. It means I'll consider that if that's what you're asking for. I'll look at all the information that gets presented, then I'll make the decision that ultimately I think was the right thing to do. Do you understand that?
Yes, Your Honor.
Now, if you are put on probation, it could be up to 5 years of supervision. As the judge, I had the discretion to order a variety of different rules and conditions for you to follow. One of the conditions could be an order that you serve a term in our Lake County Jail of up to 6 months as a condition of probation. You understand that?
Yes, Your Honor.
Further, if you are on probation to the court at any point and you ever violate the conditions of your probation, we would have a hearing to see if you're what's called a probation violator. If it was determined that you were, I could extend your probation up to 5 years if it wasn't originally 5 years. I could impose more restrictive sanctions against you, including an order that you serve time in our Lake County Jail. Or I could terminate your probation and send you to prison at that point. If I did that, again, it could be 6 to 12 months on each count. That could be consecutive, so up to possibly 24 months in prison. Do you understand that?
Yes, Your Honor.
Lastly, when we do come back here for the sentencing hearing down the road, you're going to have the right on that day to say anything you want. Anything you'd like me to know or consider, your lawyer could speak on your behalf, and she's allowed to recommend the sentence to the court. The prosecutor here is also allowed to recommend the sentence to the court. Do you understand that?
Yes, Your Honor.
Now, do you understand that whatever anyone says at sentencing regarding what they think should happen, it is just what I said. It's a recommendation. I'm not required to go along and follow that if I don't think that was the right thing to do. Do you understand that?
Yes, Your Honor.
All right, well, do you have any questions at all regarding the potential penalties you face at the time of sentencing?
No, Your Honor. You've explained it very well.
All right, so you understand all the possible consequences?
Yes, Your Honor.
And again, do you still want to plead guilty?
Yes, Your Honor.
Have you had enough time with these 2 charges here to talk about each case with your lawyer, have her review the reports with you, discuss the issues, and answer your questions?
Yes, Your Honor.
Are you satisfied with her advice and counsel?
Yes, Your Honor.
Has she, or has anyone for that matter, made you any promises about what's going to happen at sentencing, which is inducing you to plead guilty?
No, Your Honor.
Have you been threatened or coerced in any way to plead guilty?
No, Your Honor.
Are you entering the plea freely and voluntarily?
Yes, Your Honor.
All right, Mr. Nelson, any questions for me then at this time regarding anything we've just talked about, the rights you're giving up, the penalties you face, what you're pleading guilty to? Any questions at all?
No, Your Honor. I mean, you explained everything very well.
All right. Do you need any more time to talk with your lawyer before you enter your plea of guilty?
No, Your Honor.
All right, then what's going to happen at this point? The prosecutor here, he's going to set forth for the court or explain for the court what he believes the facts would show with each of these incidents. I need you to listen to what he says because I'm going to have follow-up questions for you about it, all right?
Okay. Yes, Your Honor.
Mr. DePiro?
Thank you, Your Honor. Your Honor, as to count one, the evidence would show that on January 12, 2023, about 10 o'clock at night, Painesville Police received a call from the staff at Arby's, right on the corner here, Richmond Street and Erie Street in the city of Painesville. There was somebody in the bathroom, been in there for about 15 minutes, doors locked, wouldn't respond. Painesville Police went, responded, were able to determine that it was the defendant, Ryan Nelson, who was in the bathroom locked. And at that time, he had in his front right pocket a folded piece of paper that contained methamphetamine, small little baggie, 0.18 grams of methamphetamine, Schedule II controlled substance. As to count two, Your Honor, March 2nd, 2023, Lake County Sheriff's Office received a call that there was a man walking in and out of traffic on Route 84 near Vrooman Road. It's in Perry Township, Lake County, Ohio. Sheriff's Office responded. They found that this male was the defendant, appeared to be under the influence of a drug, and in his left coat pocket he had a paper full that contained heroin, Schedule I controlled substance, and also fentanyl, Schedule II controlled substance, in the same compound. Thank you.
Mr. Nelson, were you able to hear what the prosecutor had to say regarding what he believes the evidence with both of these counts would demonstrate if we did have a trial?
Yes, Your Honor.
And what, if anything, good to say about those facts as he just presented them to the court? Are they true? Did you do what he said in each of these incidents?
Yes, they are true.
Very well then. In regards to count one, charging with aggravated possession of drugs, the drugs being methamphetamine, a Schedule II controlled substance. This is the incident from January 12th of this year. What is your plea to that count?
Guilty, Your Honor.
In regards to count two, this is the incident at Arby's, correct? That occurred on March 2nd?
No, Your Honor. January 12th was Arby's and in the city of Painesville.
Oh, right, all right, that's right. That was the first one.
Then March 2nd was the
Right,
Perry Township.
that was Perry Township. So in regards to count two, the possession of a fentanyl-related compound, a felony of the 5th degree, this is for the Perry Township incident. What is your plea to that?
Guilty, Your Honor.
All right, I have in my possession at this time a document called a written plea of guilty and judgment entry, which sets forth everything I've just explained to you about the rights you're giving up, the penalties you face, what you're pleading guilty to. Before I can accept your plea, I need to make sure you understand what's set forth in this document and that you've again signed it here in open court. Now my understanding is, again, that before I came out here, you had a chance to go over this document with your lawyer. Is that correct?
Yes, Your Honor.
Ms. Springer, is that accurate? Did you review this document with your client and read it over with him?
Yes, I did.
And did he indicate an understanding of it to you when you did that?
Yes, Your Honor.
Is that correct, Mr. Nelson?
Yes, Your Honor.
Any questions for me about what's set forth in the document?
No, Your Honor.
No, it appears that you signed this document. Did you in fact sign it?
Yes, Your Honor.
Ms. Springer, did you witness that?
Yes, Your Honor.
And Mr. DePiro, you as well?
Yes, Your Honor.
I saw that you signed it on the line where it says dated, so you drew the arrow over there, so that's your signature there, right?
Yes, Your Honor.
All right, then at this time, the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in open court with his lawyer. He was advised of all his constitutional rights and made a knowing, intelligent, and voluntary waiver of those rights. The court also finds the defendant doesn't understand the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea. Find the defendant guilty of count one, aggravated possession of drugs, a felony of the 5th degree in violation of 292511, as well as count 2, possession of a fentanyl-related compound, felony to the 5th degree in violation of 292511 of the revised code. I will defer sentencing, order a pre-sentence report and investigation, drug and alcohol evaluation, continue bond at your own recognizance with the same conditions that were previously. You're living out in Trumbull still?
No, I'm back in Lake County. I completed both my phases to residential treatment, Your Honor.
Okay, well then I guess that condition of bond is no longer needed, so you'll still remain, you'll reside here in Lake County then. So what all this means then, Mr. Nelson, as far as bond goes, I've continued your bond. There's nothing more you need to do except comply with the conditions of your bond, one of which is that you don't use any drugs while you're on bond. You have to submit urine screens if requested by the probation department. If they come back positive, your bond would be revoked and a warrant would be issued for your arrest. You understand that?
Yes, Your Honor.
Now also, this owner cognizance bond, I think you've been warned of this a couple of times, but you have to report to all, you have to show up at all future court dates. And if you fail to appear on a future court date, when you're released on an owner cognizance bond, that's a separate felony you can be prosecuted for, which is actually more serious than either of the charges you pled guilty to here today. So it's obviously important you show up at all future court dates. Do you understand that?
Yes, Your Honor.
Stan, do you have a sentencing date?
Yes, I do, Your Honor. It's July 24th at 9 o'clock.
Okay, so you got that? Your sentencing will be July 24th at 9 a.m. So you have to be here. Obviously, if you fail to be here, you can be prosecuted for failing to appear. You understand that?
Yes, Your Honor.
All right. Well, I think that covers everything. You're going to head over to the probation department from here, fill out some paperwork, get dates to come back for your reports and your interviews. So make sure you do that when you leave here.
Okay.
All right.
Thank you, Your Honor.
Mr. Shapiro, anything else?
No, Your Honor, thank you.
Ms. Springer.
Nothing
All
further.
right, thank you.
All
rise. Before you today on State versus Tammy Ferrari, file 23 CR 522. We're here today for a pretrial. It's anticipated by the state of Ohio that the defendant will withdraw her previously under pleas of not guilty and under pleas of guilty to the indictment is charged. Other than a pre-sentence investigation, no threats or promises were made to this defendant to induce this plea, and the state of Ohio is prepared to go forward. Thank you.
Thank you. There's no agreements between the parties regarding any recommendations for sentencing?
No, Your Honor, just a pre-sentence investigation.
Okay, thank you. Is that accurate?
That is, Your Honor, yes, that's a correct statement. My client would be prepared to withdraw her previously entered plea of not guilty, enter a plea of guilty to the charges as set forth by the prosecuting attorney. No threats or promises were made to induce this plea.
Thank you, sir. And it's pronounced Ferrari, is that how you pronounce the last name?
Yes, Your Honor.
Were you able to hear what the prosecutor and your attorney just had to say regarding what they believe your intentions are here at this time?
Yes, Your Honor.
It was represented to the court that they believe it's your desire to withdraw your previously entered plea of not guilty and plead guilty to the 3 counts that are set forth in this indictment. We would then defer sentencing to a later date to get some evaluations completed, come back on a later date for sentencing where there's no agreement between the parties regarding any recommendations for sentencing. Each side is free to recommend to the court whatever sentence they think is the right thing to do. Is that your understanding of the discussions that took place between your lawyer and the prosecutor, more importantly, what you want to do here today?
Yes, Your Honor.
Well, before I can accept your guilty plea, I need to make sure you understand everything going on here. I need to make sure you understand what it is you're charged with and pleading guilty to, the rights you have and the rights you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine all these issues, I will ask you a series of questions. Now, if at any point when I'm asking you these questions, if you're unsure or unclear of anything I'm asking you, if you need anything repeated or clarified, if you'd like a moment to talk with your lawyer to ask him questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right?
Yes, Your Honor.
All right. Let's get started then. How old are you, ma'am?
56 years old.
Are you able to read and write the English language?
Yes, Your Honor.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
Well, I take Adderall. I have ADHD. It takes me a minute to understand things.
When you read it, it
Yeah,
does sometimes?
Yes, and I have keratoconus. My eyes jump.
I'm sorry?
My eyes jump. I have keratoconus.
Okay. Well, there's going to come a point in time when I'm going to need you and have you read a document. Can you assure the court that if you're having any difficulty reading it or understanding what you're reading, that you'll ask for help? You'll either ask your lawyer for help, you'll ask me for help, but you'll ask for some assistance if you're having difficulty?
Of course, Your Honor.
Okay. Are you a U.S. citizen?
Yes, Your Honor.
Now, before coming into court here today, have you had any drugs or alcohol of any kind?
No.
What about in the last 48 hours?
I've had alcohol.
When
I had
was
a glass
that?
of wine
When?
a day ago.
Okay. Nothing this morning?
No.
Aside from alcohol, any drugs within the last 48 hours? Prescribed or otherwise?
Prescription, yes.
And what prescriptions would you have taken within the last couple days?
My Culotta pen last night, which was 0.5 milligrams. My Adderall, 30 milligrams, and my trazodone last night, which was 50 milligrams.
50 or 15?
50.
50. Anything else?
No.
So this medication that you've taken, and I think you just had the glass of wine last night, any of this stuff, are you currently under the influence of any of this medication or the alcohol at this time right now as you sit here, which is making it difficult for you to understand or appreciate where you are, what's going on, anything like that?
The Adderall helps me for my ADHD to concentrate, so no.
So if anything, it's helping you with that
Right,
medication.
yes. I've been on it for many years.
None of these medications are impairing your ability to appreciate your surroundings or to communicate or anything like that right now?
No, Your Honor.
All right. Now, you would have received a copy of the indictment in this case about a month ago or so. Do you remember getting that? That's the document that sets forth the charges you're pleading guilty to?
Yes, Your Honor.
And at some point you had a chance to look that over?
Yes, Your Honor.
Let me find that here. Now, in that indictment, you are charged with 3 counts. And what's alleged here in count 1 is on or about April 20th, 2021 in Painesville, Lake County, Ohio, that you did knowingly sell or offer to sell methamphetamine or some compound mixture, preparation, or substance containing methamphetamine, which is a Schedule II controlled substance. The amount involved did not equal or exceed the bulk amount, the amount involved did equal or exceed the bulk amount, but was less than 5 times the bulk amount, which makes the offense aggravated trafficking in drugs a felony of the 3rd degree. Do you understand what you're charged with and pleading guilty to in this count?
Yes, Your Honor.
Any questions about it?
I wish I didn't do it. No. No, Your Honor.
About the charge itself, though, you have any questions about what the allegations are?
No, Your Honor.
All right. Now, in count 2, you're charged with the same offense. The only difference is it's alleged that this occurred on April 22nd of 2021. But otherwise, the charge is the same. It's aggravated trafficking in drugs, and the drugs involved are methamphetamine, a Schedule II controlled substance, and an amount more than the bulk amount. Do you understand what's alleged there?
Yes, Your Honor.
Any questions about that charge?
No, Your Honor.
Lastly, count 3, again, is the same offense. The only difference, again, is that it occurred on April 28th of 2021. Otherwise, all the allegations are the same, that you knowingly sold or offered to sell methamphetamine, Schedule II controlled substance to another person, and the amount was more than the bulk amount. That is aggravated trafficking in drugs, and it's also a felony of the 3rd degree. You understand what you're charged with and pleading guilty to in count 3?
Yes, Your Honor.
Sorry?
Yes, Your Honor.
Okay. So any questions about any of the 3 charges?
No, Your Honor.
Well, before I can accept your guilty plea, then I need to make sure you understand all the rights you're giving up by pleading guilty. And you first of all have a right to have a trial in this case. And the trial could be to me as a judge, where I listen to all the evidence and I make that ultimate decision whether you're guilty or not guilty. But you also have a constitutional right to have a jury trial. And a jury trial would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. The jurors would consider and weigh all that evidence, and then those 12 jurors would make that ultimate decision. And that ultimate decision reached by the 12 jurors would have to be a unanimous decision. What that means is all 12 jurors would have to agree together, one way or the other, as to each charge, whether you're guilty or not guilty. Do you understand that?
Yes, Your Honor.
Do you understand by pleading guilty, you're giving up your right to have a trial in this case?
Yes, Your Honor.
Now, if you had a trial, you'd have the right to have a lawyer represent you at the trial. If you cannot afford a lawyer to represent you at your trial, the court would appoint one for you free of charge to do that. Do you understand that?
Yes, Your Honor.
Now, at a trial, the prosecutor here would be representing the state of Ohio, and he would have what we refer to as the burden of proof. Now, by the prosecutor having the burden of proof, what that actually means, it's his job, or he bears the responsibility or the obligation. He bears the burden of proving you guilty before you could ever be found guilty. You are presumed innocent of the charge. Presumption of innocence remains with you and stays with you until the state, if at all, is ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes, Your Honor.
Now, when I speak of this burden of proof, since it's a criminal case we're dealing with, the burden of proof is what we refer to as proof beyond a reasonable doubt. And that's the highest burden of proof there is in our justice system. And what it means, it's the amount of the evidence and the quality of the evidence the state has presented at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of the offense beyond any reasonable doubt before you could ever be found guilty at a trial of these charges. Do you understand that?
Yes, Your Honor.
Do you understand by pleading guilty or giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt?
Yes, Your Honor.
Now, in order to do that, or at least in order to try to do that, the prosecutor here will be bringing witnesses to come into the courtroom to testify for the state by answering questions from the prosecutor. Now, once those witnesses answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same person's questions. We call that cross-examination. He could ask him anything he wanted to within certain rules. Do you understand that?
Yes, Your Honor.
Do you understand by pleading guilty or giving up your right to cross-examine or confront these witnesses that would come in here and testify against you?
Yes, Your Honor.
Now, you'd also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That's a decision or a choice that you would have to make. Do you understand that?
Yes, Your Honor.
And since that's your choice, what that really means then is that nobody else could force you or make you, nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify, but more importantly, the prosecutor here, he's not allowed to call you as a witness and make you get up on the stand and testify Your own lawyer can't make you testify if you don't want to. Do you understand that?
Yes, Your Honor.
You further understand that if we did go to trial and you were found guilty of any of these 3 charges, you would have the right to appeal or challenge that guilty finding to a higher court that's above me. By pleading guilty here today to these charges, you are giving up your right to appeal any guilty finding that I will make if your plea is accepted, as well as any other issues I could have raised or brought, any other issues you could have raised or brought to my attention up to this time. You understand that?
Yes, Your Honor.
All right. Well, do you have any questions at all about these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
No, Your Honor.
Do you understand them all?
Yes, I do.
Do you still want to plead guilty?
Yes, I'm guilty.
Do you understand a guilty plea is a complete admission of guilt? That means you'll be admitting to the facts being alleged by the prosecutor here. We're not going to argue you didn't do it or it's someone else's fault or anything like that. Do you understand that?
Yes, Your Honor.
Further, as a result of pleading guilty, the effect of that plea is that you will be found guilty by the court, and then you will subsequently, on another day, be sentenced by the court. Do you understand that?
Yes, Your Honor.
Now, as far as sentencing goes, you're pleading guilty to 3 felonies of the 3rd degree. Each of these charges carry with it a possible term in prison of a minimum of 9 months, a maximum of 36 months, or increments in between of either 12, 18, 24, 30. So if I impose a prison sentence on any of these counts, I'd select one of those numbers, 9, 12, 18, 24, 30, or 36, and that'd be the number of months in prison you'd have to serve for that particular count. Do you understand that?
Yes, Your Honor.
And if I did it, it doesn't have to be the same. It could be one number for count 1, a different number for count 2, etc. Each one's their own separate offense. You understand that?
Yes, Your Honor.
Now, in regards to these 3 counts, if I did impose a prison sentence on them, as the judge, I had the discretion to run those prison terms either concurrent or consecutive to each other. So concurrent means you'd serve them together at the same time, whereas consecutive means one after the other. You'd serve the prison term on count 1, whatever it is, finish that, then serve the term on count 2, and etc. And for count 3. You understand the difference between concurrent and consecutive?
Yes, Your Honor.
So for this particular case, you need to make sure you understand the maximum prison term you face. If I impose the maximum sentence on each count and ran each of the 3 counts consecutive to each other, there's a maximum prison term in this case that could be imposed of 9 years. Do you understand that?
Yes, Your Honor.
Now, are you currently on probation or parole, post-release control, any type of supervision, any other courts
No,
or
Your Honor.
agencies? Do you have any other charges pending against you anywhere?
Not that I know of, Your Honor.
If a prison sentence were imposed in this case, upon your release from prison, you could be placed on what we refer to as post-release control. It's sometimes called parole. That's a period of supervision you would be on after you serve the prison sentence. And in this case, it could be up to 2 years. Do you understand that?
Yes, Your Honor.
And if you were at any point placed on post-release control and ever violated the conditions of your supervision, the parole authority could return you to prison as punishment for violating their rules for another 9 months for each separate violation you committed, up to an overall maximum of 50% or half of whatever the prison term was imposed by the court. Do you understand that?
Yes, Your Honor.
Now, aside from the possible prison sentence, there are other sanctions that could be ordered. You could be, you will be fined in this case. There's a mandatory fine on each count here that by at least $5,000 that must be imposed, and you could be fined up to $10,000 on each count. Do you understand that?
Yes, Your Honor.
So there'll be a minimum fine with each of the counts of at least $15,000 imposed, and you could be fined a total of $30,000 total. Do you understand that?
Yes, Your Honor.
You could also be ordered to pay court costs or reimburse the county for any costs of confinement, community supervision, or treatment if any of that were applicable. Do you understand that?
Yes, Your Honor.
There's also a possible driver's license suspension that could be imposed in this case of up to 5 years. Do you understand that?
Yes, Your Honor.
Now, a few moments ago, I explained to you the possible prison sentence you face by pleading guilty. I did use the word possible because prison is not mandatory in this case. You are eligible for probation or what is referred to as community control sanctions. Do you understand that?
Yes, Your Honor.
Now, just because you're eligible doesn't mean you will automatically be put on probation. It means it'll be considered by the court if that's what you're going to be asking for. I'll look at all the information that gets presented to the court, then I'll make the decision I think is the right thing to do. Do you understand that?
Yes,
Now, while you are eligible for probation, I need to advise you that the 3 charges you're pleading guilty to each carry with it a presumption that a prison term be imposed, which means that the court is required to impose a prison sentence unless certain findings can be made by the court that would overcome that presumption and permit me to impose community control sanctions. You understand that?
yes, Your Honor.
Now, if you are put on community control sanctions at any point, as the judge, I have the discretion to order or authority to order a wide variety of different rules and conditions for you to follow. One of the conditions could be an order that you serve a term in the Lake County Jail of up to 6 months as a condition of probation. Do you understand that?
Yes, Your Honor.
So what that means is that even if you're given probation, doesn't mean automatically mean there's no jail time. It means there still could be local jail time of up to 6 months. Do you understand that?
Yes, Your Honor.
Now, if you are put on probation, you ever violate any of the conditions of your supervision, we'll have a hearing here in court to see if you're what's called a probation violator. And if it is determined that you are, I could extend your probation up to 5 years if it wasn't originally 5 years. I can impose more restrictive sanctions against you, which could include an order that you serve time in jail, or I could terminate your probation and send you to prison at that point. If I did it at that stage, again, it could be 9 to 39, 12, 18, 24, 30, or 36 months on each count. It could be consecutive, so possibly up to 9 years in prison. You understand that?
Yes, Your Honor.
Lastly, when we do come back here for sentencing, you're going to have the right on that day to say anything you want. Anything you want me to know or consider. Your lawyer's allowed to speak on your behalf. He's allowed to recommend a sentence to the court. The prosecutor can also recommend a sentence to the court. Do you understand that?
Yes, Your Honor.
Do you understand that whatever anyone says at the time of sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation. I'm not required to follow that if I don't think that's the right thing to do. Do you understand that?
Yes, Your Honor.
All right, well, do you have any questions for me regarding the potential penalties you face by pleading guilty here?
No, Your Honor.
Do you understand all the possible consequences?
Yes.
Do you still want to plead guilty?
Yes.
Have you had enough time to go over this case with your attorney and have him review the report with you, discuss whatever issues there may be, and answer whatever questions you have?
Yes, Your Honor.
Are you satisfied with the advice and counsel of your attorney?
Yes.
Has he, or has anyone for that matter, made you any promises about what's going to happen at sentencing which is inducing you to plead guilty?
No.
Have you been threatened or coerced in any way to plead guilty?
No.
Are you entering the plea freely and voluntarily?
Yes.
All right, then. Do you have any questions for me at this time regarding anything we've just talked about? The rights you're giving up, penalties you face, what you're pleading guilty to? Any questions at all?
No, Your Honor.
Do you need any more time to speak with your lawyer before we go forward with the actual plea?
No, I don't.
All right, then what's going to happen at this point is the prosecutor here, he's going to explain for me what he believes the evidence regarding each of these 3 counts would show if we did have a trial. I need you to listen to what he says because I'm going to have some follow-up questions for you about that then, all right?
Okay.
All right. Mr. Gagris, please.
Thank you, Your Honor. The evidence would show that in the month of April 2021, the defendant was, an investigation into the defendant was opened by Lake County Narcotics, and she was targeted by a confidential informant for a series of buys. First buy occurred on April 20th, 2021. The defendant agreed to exchange methamphetamine for $475. The deal occurred at 69 East Prospect Street in the city of Painesville, Lake County, Ohio. The deal did in fact occur, and the items were sent to Lake County Crime Lab where they tested positive for methamphetamine Schedule 2 in amount which exceeded bulk but less than 5 times bulk. She was again targeted on April 22nd, 2021. The deal again occurred at 69 East Prospect Street in the city of Painesville, Lake County, Ohio. The defendant agreed to exchange methamphetamine for U.S. currency. The deal did in fact occur. The suspected narcotics were sent to Lake County Crime Lab where they tested positive for methamphetamine Schedule 2 in amount that exceeded bulk but less than 5 times bulk. And lastly, she was targeted on April 28, 2021. Again, the deal occurred at 69 East Prospect Street in the city of Painesville, Lake County, Ohio. The defendant agreed to exchange methamphetamine for $500, or actually $480. Suspected narcotics were sent to the County Crime Lab where they tested positive for methamphetamine Schedule 2 in amount that exceeded bulk but less than 5 times bulk. Thank you.
Thank you. So, Ms. Ferrari, were you able to hear what the prosecutor had to say regarding what he believes the evidence would establish if we did have a trial in this case?
Yes, Your Honor.
And what, if anything, do you have to say about those facts as he just presented them? Are they accurate? Did you do what he said in each of those 3 occasions?
Yes, I did.
Very well, then. Regarding counts 1, 2, and 3, each charging you with the offense of aggravated trafficking in drugs, where the drugs were methamphetamine, Schedule II controlled substance, and an amount more than the bulk amount. What is your plea to each of those 3 counts at this time?
Guilty, Your Honor.
All right, you can be seated. I have in my possession at this time a document called a written plea of guilty and judgment entry. This is the paperwork I was talking about earlier that I'm going to need you to review. This document sets forth basically everything I've just explained to you about what you're pleading guilty to, the rights you're giving up, the penalties you face. Before I could accept your plea, I need to make sure you understand what's in this document, that you signed it here in open court. Now, my understanding is before I came out here today, you had a chance to go over this document with your attorney. Is that correct?
Yes, Your Honor.
Mr. Levy, is that accurate? Did you read this over with your client, especially in this particular case? You read it to her to make sure she understood it?
Yes, Your Honor, I did.
Answer all her questions?
Yes, Your Honor.
Did she indicate an understanding of it to you when you went over it with her?
Yes, Judge.
Okay, is that correct, Ms. Ferrari?
Yes, Your Honor.
So you understand what's in this document when you read it to you?
Yes.
I want to make sure, because you said you may have some difficulty understanding what you read, so I want to make sure that it's all clear to you. Is that the case?
Yes, it's clear.
Any questions for me about what it says?
No, Your Honor.
Now, the only thing I'll add is that this document, it's identical to what you read, except I did add in here the medications that you told me before, where it says you've not taken any drugs or alcohol in a 48-hour period. I did say except for alcohol, Klonopin, Adderall, and Trazodone. Those are
Yes,
what you
that's
told
right.
me. Aside from that, it's identical to what you signed. Any questions about this?
No, Your Honor.
And as I just alluded to, it does appear on the last page that there's a line that says signature of defendant that you did sign it. Did you in fact sign it?
Yes, I did, Your
Mr.
Honor.
Levy, did you witness that?
Yes, Judge.
And Mr. Geigerich?
Yes, Your Honor.
Thank you. All right, this time the court will accept the defendant's oral and written plea of guilty. Let the record reflect. The defendant was here in open court with her lawyer. She was advised of all her constitutional rights and made a knowing, intelligent, and voluntary waiver of those rights. Court also finds the defendant does understand the nature of the charges, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea, finding the defendant guilty of counts 1, 2, and 3, aggravated trafficking in drugs, each felonies of the 3rd degree, and each in violation of 2925.03A1 of the revised code. I will defer sentencing, order a pre-sentence report and investigation, drug and alcohol evaluation, and continue defendant's bond at her own recognizance. So what all this means at this point, Ms. Ferrari, as far as bond goes, I'm continuing your bond. You've already posted that when you signed the original paperwork. So there's nothing more you need to do. You do need to comply with the conditions of bond. One is that you don't use any drugs while you're on bond. And you must submit urine screens if requested. If they're requested, you have to provide it, and they must be negative. A positive screen will result in your bond being revoked and a warrant being issued for your arrest. Do you understand that?
Yes, Your Honor.
Also, that OR bond, you were advised of this on the day that you signed it, but you must appear at all future court dates for when you're on an OR bond. You have to appear at all future court dates for any bond. But if you're on an OR bond and you fail to appear, that's a separate felony you can be prosecuted for. It's a felony of the 4th degree, which you can get an additional 18 months in prison on if you fail to appear. So it's important that you show up at all future court dates. You understand that?
Yes, Your Honor.
And Mr. Shadow, when's the sentencing date?
July 24th at 9:45.
So the next court date is July 24th at 9:45 a.m. So
May I check my calendar, Your Honor?
Sure. So that's the next court date that you need to appear for. And again, if you fail to appear for it, that's a separate criminal charge that we prosecute. You understand that?
Yes, Your Honor.
All right. Now, this pre-sentence report, the drug and alcohol evaluation I ordered, those are reports for the purposes to give me information about you and your background so I could learn more about you before sentencing. Now, the way the probation department gets the information they need to prepare those reports, they're going to conduct an interview with you. They're going to also administer some tests. It's important that when you speak with them and answer their questions, that you're open and honest with them, because they're going to check and verify everything you tell them. In fact, the testing is designed to tell whether someone's answering the questions openly and honestly. And if they learn you're misleading them some way, whether it's maybe nothing is egregious, but you're exaggerating something or minimizing something or flat out lying, they're going to let me know that. Now, I'll consider that sentencing. You understand that?
Yes, sir.
All right. So you're going to leave here right now. You're going to go over to the probation department. Do you know where that is or not?
No.
Okay. Mr. Levy, do you know where that is? The third floor of the sheriff's department.
Okay.
So you're going to go over there now, fill out some initial paperwork, and get your dates to come back for your interview. So make sure you go over there when you leave here at this time, all right?
Yes, Your Honor.
Okay. I think that covers everything. Mr. Geigerich, is there anything else I forgot or need to address?
Yes, Your Honor. The defense counsel indicated to me earlier he would like his client to be evaluated for the dual diagnosis program.
Well, we can do a psychological evaluation as well then. Would you prefer that?
Thank you, Your Honor. Yeah, he took the words out of my mouth.
Okay. Well, we'll do a psych evaluation as well then. So pre-sentence report, drug and alcohol evaluation, psychological evaluation. Okay. Anything else then for the defense?
No, Your Honor, that was all. Thank you.
Mr. Geigerich, anything more for the defense?
Nothing, Your Honor. Thank you.
Gardner, case number 23CR339. Defendant is present in open court with his counsel, Lauren Tuttle. We're here today on a 2-count information filed on May 18th of 2023. It's the state's understanding that the defendant will waive his right to be indicted and plead to count 1, carrying concealed weapons, a felony of the 4th degree, in violation of 2923.12A2 with the attached forfeiture specification, as well as count 2, attempted tampering with evidence, a felony of the 4th degree, in violation of 2923.02 and 2921.12A1. The state would ask to defer sentencing and that the court order a pre-sentence report. There has been an agreed sentencing recommendations between the parties that the state will recommend community control sanctions. That is contingent on the defendant continuing to comply with the conditions of his bond.
Thank you. Ms. Tuttle, does that all sound accurate?
It does, Your Honor, and Carl's prepared to plead guilty by way of information today.
And Mr. Gardner, were you able to hear what the prosecutor and your lawyer just had to say regarding what they believe your intentions are here today?
No, Your Honor.
Sorry?
No, Your Honor.
You weren't able to hear what she just said?
Oh, yes, Your Honor.
And what your attorney said?
Yes.
They indicated to the court that they believe it's your desire to waive your right to have this case presented to a grand jury, and I'll explain to you in a minute what that means here in more detail. Then you're going to go ahead and plead guilty to the 2 charges that are set forth in the information, which I will also go over with you here to make sure you understand them. We'll then defer or continue the sentencing to a later day to get some reports completed, then come back on a future date where it's been represented that there'll be a joint recommendation that community control sanctions, another word for probation, be imposed at the time of sentencing. Is that your understanding of the discussions that took place between your lawyer and the prosecutor's office and what you want to do here today?
Yes, Your Honor.
Well, before I can accept your guilty plea, I need to make sure you understand everything we're doing here. I need to make sure you understand what it is you're charged with and pleading guilty to, the rights you have and the rights you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine all those issues, I will ask you at this time a series of questions. Now, if at any point when I'm asking you these questions, if you're unsure or unclear of anything I'm asking you, if you need anything repeated or clarified, if you'd like a moment to talk with your lawyer so you could ask her questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything that's going on, all right?
Okay, Your Honor.
All right. Well, let's get started then here. How old are you, sir?
18 years old.
Are you able to read and write the English language?
Yes, Your Honor.
You have any difficulty with that or difficulty understanding what you read in the English language?
No, Your Honor.
Are you a U.S. citizen?
Yes,
When did you turn 18?
August 4th, 2022.
Now, before you came into court here, did you receive a copy of the information? That's the document that sets forth the 2 charges that you're going to be pleading guilty to. Did you receive that?
Yes, Your Honor.
And at some point you had a chance to go over that?
Yes, Your
Look that over? Now, in that information, there are 2 counts. Count 1, what's alleged here, and what you'll be admitting to is on or about March 12th, 2023 in Lake County, Ohio, that you did knowingly carry or have concealed on your person or concealed ready at hand a handgun, specifically a Springfield Armory XD subcompact 9x19 pistol. And the firearm was either loaded or that you had ammunition ready at hand, which makes the offense carrying concealed weapon a felony of the 4th degree. Do you understand what you're charged with and pleading guilty to in this count?
Yes, Your Honor.
Any questions about it?
No, Your Honor.
Now, the count also carries with it what we call a forfeiture specification, which alleges during the commission of the offense, you possess or had an interest in property that was considered to be contraband or an instrumentality. Contraband is property that's illegal to possess because of either there's the nature of the property it's illegal or because of the circumstances of the person make it illegal. Whereas an instrumentality is some type of property that there may not be anything illegal about it, but it's being used in an illegal manner to facilitate a crime, and you can't possess it for that purpose. And here it's alleged the firearm itself was contraband or instrumentality along with ammunition, some marijuana, digital scales, and methamphetamine. The whole purpose of this specification is that you forfeit any right you have to that property at the time of sentencing. You understand that?
Yes, Your Honor.
Any questions about the specification?
No, Your Honor.
Now, in count 2, what's alleged here and what you're pleading guilty to is on or about March 12, 2023 in Lake County, Ohio, that you did purposely or knowingly and with sufficient culpability for the commission of the offense of tampering with evidence, that you engaged in conduct, if successful, would have resulted or constituted the offense of tampering with evidence, which is, and what tampering with evidence prohibits is that prohibits a person who knows that an official proceeding or investigation is in progress or it's about to be or likely to be instituted, that person altered, destroyed, concealed, or removed anything with purpose to impair its value or availability as evidence in such proceeding or investigation. So that conduct that I just explained is what tampering with evidence is. You're pleading guilty to a charge that's called attempted tampering with evidence, which means you engage in conduct that, if was successful, would have resulted in the offense of tampering with evidence. Does that make sense to you?
Yes, Your Honor.
And the biggest significance of that is that it reduces it from a felony of the 3rd degree to a felony of the 4th degree. A felony of the 4th degree is less serious than a felony of the 3rd degree. So you're pleading guilty to a less serious offense than the regular tampering with evidence. You understand that?
Yes, Your Honor.
So do you have any questions at all about the charge you're actually pleading guilty to?
No, Your Honor.
Well, then before I can accept your guilty plea, I need to make sure you understand all the rights you're giving up by pleading guilty. And you, first of all, have the right to have this case presented to a grand jury. So that document that I just read to you that you have in front of you is called an information. An information is a criminal charge or charges that are brought by the prosecutor's office without this case having previously been reviewed or considered by a grand jury. Now, what a grand jury is, it's made up of a group of citizens here from Lake County that get together and meet privately. They meet in secret for the purpose of evaluating evidence in cases to determine whether probable cause exists that someone committed a crime. Probable cause is defined as some evidence that would suggest a person probably committed a criminal offense. Everyone here in the state of Ohio accused of a felony has the right to have a grand jury independently review the evidence in a case and make a decision without the government being involved in that decision whether someone should be charged or not. And you have that right as well. But you can give up that right if you desire and go forward on the charge brought by the prosecutor in the information, and your attorney has indicated she believes that's how you want to proceed here today. Is that correct?
Yes, Your Honor.
Well, before I can go any further, I need to have you acknowledge that here in open court in writing. And I have in my possession at this time a one-page document called a waiver of indictment, which sets forth and explains everything I've just explained to you about the grand jury process, and that you want to give up that right. Before I can go any further, I need to be assured you understand what's in this document and that you sign it here in open court. Now, my understanding is that before I came out onto the bench here, you had a chance to go over that document with your lawyer. Is that correct?
Yes, Your Honor.
Ms. Tuttle, is that accurate? Did you read this to your client and go over it with him?
I did, Your Honor. I read the document to him. He indicated an understanding of the same, and we both signed that document.
Is that correct, sir?
Yes, Your Honor.
Any questions for me about what it says?
No, Your Honor.
And did you, in fact, sign it as indicated by your lawyer?
Yes, Your Honor.
Ms. Contour, you witnessed that as well?
I did, Your Honor.
All right, then I will make this document part of the record. At this point, Mr. Gardner, I'm required to go over all the other rights you have that you're giving up by pleading guilty, so we're going to do that at this time. Again, if you have any questions, make sure you ask. But first of all, you have a right to have a trial in this case. Now, a trial could be to me as a judge, where I listen to all the evidence and I make that ultimate decision whether you're guilty or not guilty of each charge. But you also have a constitutional right to have a jury trial. And a jury trial would be in front of 12 citizens here from Lake County who would listen to all the evidence that each side wanted to present. Those 12 jurors would consider and weigh all that evidence, and then those 12 jurors would make that ultimate decision. And that ultimate decision reached by the 12 jurors would have to be a unanimous decision. What that means is all 12 jurors would have to agree together, one way or the other, whether you were guilty or not guilty of the charges. Do you understand that?
Yes, Your Honor.
Do you understand by pleading guilty you're giving up your right to have a trial in this case?
Yes, Your Honor.
Now, if we had a trial, the prosecutor here would be representing the state of Ohio, and she would have what we refer to as the burden of proof. Now, by her having a burden of proof, what that actually means, it's her job, or she bears the responsibility or the obligation of proving you guilty at a trial before you could ever be found guilty. You are presumed innocent of these two charges, and the presumption of innocence sticks with you and remains with you until the state, if at all, was ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes, Your Honor.
Now, when I talk about the burden of proof, since this is a criminal case, that burden of proof is what we refer to as proof beyond a reasonable doubt. And that is the highest burden we have in our justice system. And what it actually means, it's the amount of the evidence and the quality of the evidence the state would have to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of the criminal offenses beyond any reasonable doubt before you could ever be found guilty. Do you understand that?
Yes, Your Honor.
Stand by pleading guilty or giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt at a trial?
Yes, Your Honor.
Now, in order to do that, or at least in order to try to do that if we had a trial, the prosecutor would bring witnesses into the courtroom to testify for the state by answering questions from the prosecutor. Now, once those witnesses answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same persons questions. That's called cross-examination. So she would be allowed to ask them anything she wanted to within certain rules. Do you understand that?
Yes, Your Honor.
Do you understand by pleading guilty or giving up your right to cross-examine or confront these witnesses that would come in here and testify against you?
Yes, Your Honor.
Now, you'd also have the right at a trial. You could call your own witnesses to come to court and testify for you if you wanted to and answer your lawyer's questions. Now, you're not required to do that, but you have the right to do that if you wanted. Do you understand that?
Yes, Your Honor.
And you further can request the court issue an order, and we call that order a subpoena. What a subpoena would actually do is it would force or make someone come into court and testify for you and answer your lawyer's questions if they were not willing to do so voluntarily. Do you understand that?
Yes, Your Honor.
Do you realize you're giving up that right?
Yes, Your Honor.
You also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That's a decision or a choice that you would have to make. Do you understand that?
Yes, Your Honor.
And since that's your choice, what that really means then is that nobody else could force you or make you, nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify, but more importantly, the prosecutor here, she's not allowed to call you as a witness at your trial and make you get up on the stand and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes, Your Honor.
Further understand that if we did go to trial and you were found guilty, you would have the right to appeal or challenge that guilty finding to a higher court that's above me. By pleading guilty here today, you are giving up or waiving any right you have to appeal a guilty finding. This court will enter if your plea is accepted, as well as any other issues you could have raised or brought to my attention up to this time. Do you understand that?
Yes, Your Honor.
All right, well, do you have any questions at all about these rights we just discussed here? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
No, Your Honor.
Do you understand them all?
Yes, Your Honor.
Do you still want to plead guilty?
Yes, Your Honor.
Now, do you understand a guilty plea is a complete admission of guilt? It means you're admitting to the facts being alleged by the prosecutor. We're not going to argue later that you didn't commit the offense or it's someone else's fault or anything like that. Do you understand that?
Yes, Your Honor.
Further, as a result of pleading guilty, the effect of that plea is that you'll be found guilty by the court, and then you will subsequently, on another day, be sentenced by the court. Do you understand that?
Yes, Your Honor.
Now, as far as possible sentencing goes, you're pleading guilty in this case to 2 felonies of the 4th degree. Each of these charges carry with it a possible term in prison of a minimum of 6 months, a maximum of 18 months, or any whole number within that range of 6 to 18. Do you understand that?
Yes, Your Honor.
Now, since we have 2 separate charges here, if the court did impose a prison sentence, I would impose a prison term on each count. And then as the judge, I had the discretion to run those prison terms either concurrent with each other or consecutive to each other. Concurrent means you'd serve them together at the same time, whereas consecutive means one after the other. You'd serve the prison term on the first count first, finish that, then serve the prison term on the next count. Do you understand the difference there?
Yes, Your Honor.
Any questions about that?
No, Your Honor.
So in this particular case, if I imposed the maximum prison sentence on each count and ran the terms consecutive to each other, you're facing a maximum possible prison term of 3 years in prison. Do you understand that?
Yes, Your Honor.
Now, are you currently on probation or parole to any other courts or agencies?
No.
Why you're hesitating about something?
I was gonna ask, were you trying to see if, like, that was my OR bond, like, because I know the conditions are.
No, I'm not concerned about that. Probation is what I'm referring to. Are you on probation to any other courts or agencies?
No, Your Honor.
And the only reason I'm asking that is just because if you are on probation and you commit a new crime when you're on probation, there could be consequences with that court because you committed a new offense while on probation. That's not an issue here, right? Sounds like.
No, Your Honor.
Okay. Do you have any other charges pending against you anywhere else?
No, Your Honor.
Okay. If a prison sentence were imposed at any point in this case, upon your release from prison, you could be placed on what we call post-release control. It's also referred to sometimes as parole. It's a period of supervision you would be on after you served and completed the prison sentence. And in this case, it could be up to 2 years of supervision. You understand that?
Yes, Your Honor.
And if you were put on post-release control and you ever violated any of the conditions of your supervision, the parole authority could send you back to prison as punishment for not following their rules for another 9 months for each separate violation you commit, up to an overall maximum of 50% or half of whatever the prison term was imposed by the court. Do you understand that?
Yes, Your Honor.
Now, in addition to the possible prison sentence, there's other penalties or sanctions that could be ordered. You could be fined in this case up to $5,000 on each count. So together there's a maximum possible fine of $10,000. You could be ordered to pay court costs. You could also be ordered to reimburse the county for any costs of confinement, community supervision, or treatment if any of that were applicable in this case. Do you understand that?
Yes, Your Honor.
Also, in regards to that forfeiture specification I read to you earlier, any right, title, or interest you have in any of that property, it would be ordered to be forfeited to the state of Ohio at the time of sentencing. Do you understand that?
Yes, Your Honor.
Now, a few moments ago, I explained the possible prison sentence you face by pleading guilty here today. I did use the word possible because prison is not mandatory or required in this case. You are eligible with these charges to be placed on probation or what's called community control sanctions. Do you understand that?
Yes, Your Honor.
Now, do you understand that just because you're eligible doesn't mean you will automatically be put on probation? It means I will consider that if that's what you're asking for. It appears you are because there's a joint recommendation for that. So I certainly will consider that request. I'll look at all the information that gets presented to the court. Then I'll make the decision ultimately that I think is the right thing to do. Do you understand that?
Yes, Your Honor.
Now, if you are put on probation, it could be for up to 5 years of supervision. And as the judge, I do have the discretion to order a wide variety of rules or conditions for you to follow. One of the conditions could be an order that you serve a term in the Lake County Jail of up to 6 months as a condition of probation. So just because if the court were to grant you probation, that doesn't automatically mean no jail time. It could, but there's also a possibility of doing 6 months of local jail time in the Lake County Jail. Do you understand that as a condition of your probation?
Yes, Your Honor.
Further, if you are put on probation at any point by this court for this case, and you ever violate any of the conditions of your probation, we would have a hearing to see if you're what's called a probation violator. And if it was determined that you were, I could extend your probation up to 5 years if it wasn't originally 5 years. I could impose more restrictive sanctions against you, including an order that you serve time in our Lake County Jail, or I could terminate your probation at that point and send you to prison then. If I did it at that point, again, it could be 6 to 18 months on each count. That could be ordered to be served consecutive, so possibly 36 months or 3 years in prison. Do you understand that?
Yes, Your Honor.
Lastly, when we do come back here for the sentencing hearing, you're going to have the right on that day to say anything you want. Anything you'd like me to know or consider. Your lawyer could speak on your behalf. She's allowed to recommend the sentence to the court. The prosecutor can also recommend the sentence to the court. Do you understand that?
Yes, Your Honor.
Do you understand that whatever anyone says at sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation. I'm not obligated or required to follow that if I didn't think that was the right thing to do. Do you understand that?
Yes, Your Honor.
All right. Well, do you have any questions at all about the potential penalties you face by pleading guilty here?
No, Your Honor.
You understand all the possible consequences?
Yes, Your Honor.
You still want to plead guilty?
Yes, Your Honor.
Have you had enough time to talk about this case with your lawyer, have her review the report with you, discuss the issues, answer your questions? I understand you were also, Mr. Matthews is who you've been talking with mainly, correct?
Yes, Your Honor.
Enough time to talk about the case with him?
Yes, Your Honor.
Are you satisfied with the advice and counsel of your lawyers?
Yes, Your Honor.
Any of them, or anyone for that matter, whether a lawyer or someone else, anyone make any promises to you about what's going to happen at the time of sentencing?
No, Your Honor.
I know there's a joint recommendation for probation, so the prosecutor has promised to recommend that, and they're bound to that promise, assuming you live up to your end of the bargain with the conditions of bond. But has anyone promised you that that's actually what's going to happen here?
No, Your Honor.
Have you been threatened or coerced in any way to plead guilty?
No, Your Honor.
Are you entering the plea freely and voluntarily?
Yes, Your Honor.
All right, then any questions for me at this time regarding anything we've just talked about, the rights you're giving up, the penalties you face, what you're pleading guilty to? Any questions at all?
No, Your Honor.
Do you need any more time to talk with your lawyer before we go forward with your actual plea of guilty here today?
No, Your Honor.
All right, then I'll tell you what's going to happen now is the prosecutor here is going to explain for me what she believes the evidence in this case would show if we did have a trial. I need you to listen to what she says because I will have some follow-up questions for you about that, all right?
Okay, Your Honor.
Ms. Contra, please state.
Thank you, Your Honor. Had this matter proceeded to trial, the state would have been prepared to show beyond a reasonable doubt that on March 12th of 2023 in Lake County, state of Ohio, officers initiated a traffic stop on a vehicle in which the defendant was the front passenger. While speaking to the occupants, the officer smelled a strong smell of marijuana coming from the vehicle, and a probable cause search was conducted. After removing a piece of the center console, a concealed firearm was located. It was loaded and it was sent to the Lake County Crime Lab. It was found to be operable. In speaking with the defendant, he did state that the firearm was his, and at that time, officers noticed that the defendant appeared to have something in his mouth in the back of the patrol vehicle. He was ordered to spit it out and spat out a large bud of marijuana, which he had attempted to swallow. Thank you.
What about methamphetamine?
Your Honor, there was several pills found in the back of the vehicle in a satchel.
Okay.
It was found to be methamphetamine. The defendant did take responsibility of that, but that was with regards to the methamphetamine.
The only reason I asked that's because it's part of the specification, so I hadn't heard anything about that. So, Mr. Gardner, were you able to hear what the prosecutor just had to say regarding what she believes the evidence in this case would show if we did have a trial?
Yes, Your Honor.
And what, if anything, do you have to say about those facts as she just presented them to the court? Are they true? Did you do what she said?
Yes, Your Honor.
Very well, then, regarding count one, charging you with carrying a concealed weapon, a felony of the 4th degree with the forfeiture specification, what is your plea to that?
Guilty.
Regarding count two, charging with attempted tampering with evidence, a felony of the 4th degree, what is your plea to that?
Guilty.
All right, I have in my possession at this time another document. This is a 4-page document called a written plea of guilty and judgment entry, which sets forth and explains everything I've just discussed with you. What you're pleading guilty to, the rights you're giving up, the penalties you face. Before I can accept your plea, I need to make sure you understand what's in this document and that you sign it here in open court. Now, my understanding is before I came out here, you had a chance to go over that document with your lawyer as well. Is that correct?
Yes, Your Honor.
Ms. Tuttle, is that accurate? Did you read this over with your client and review it with him?
I did, Your Honor. I read the document to him. He indicated an understanding of the document, and we both signed it.
Is that correct, Mr. Gardner?
Yes, Your Honor.
Do you have any questions for me about what the document says?
No, Your Honor.
And did you in fact sign? What is that? Did you in fact sign it?
Yes, Your Honor.
Ms. Contour, you witnessed that as well?
I did, Your Honor.
Very well, then. At this time, the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in open court with his lawyer advised of all his constitutional rights and made a knowing, intelligent, and voluntary waiver of all those rights. The court also finds the defendant does understand the nature of the charges, the effect of the guilty plea, as well as the maximum penalty that can be imposed here today. Finding this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea and find the defendant guilty of count one, carrying concealed weapon, a felony of the 4th degree, in violation of revised code section 2923.12A2, as well as count 2, attempted tampering with evidence, a felony of the 4th degree, violation of 292302 and 2921.12A1. I will defer sentencing, order of pre-sentence report investigation, drug and alcohol evaluation, and I'll continue defendant's bond and his own recognizance. So what all this means, as far as your bond goes, your bond was already previously set. We don't need the new form here because it was our...
Your Honor, there is one thing I would like to address regarding drug testing today. So Mr. Gardner has been fully honest with me about the fact that he has not smoked marijuana since his release from jail. However, there is an incident that he would like to make the court aware of. Last week he was given a brownie by his cousin. His cousin, after he had eaten it, as a joke, said, "This has marijuana in it." Carl, to this day, is not entirely sure if that did have marijuana in it. It didn't really affect him in any way, but he wants the court to be aware that if there was, in fact, marijuana in his system, he did not take it purposely. He would ask the court for an opportunity to perform a secondary drug test to see if those levels do go down.
We'll see what happens with the first test.
Thank you, Your Honor.
Anyway, we have a prior OR bond form that was filed. We'll use that. There's no need for a new one. So I'll continue the bond for now. One of the conditions of your bond is that you don't use any drugs. You have to submit urine screens. If they come back positive, your bond can be revoked and a warrant could be issued for your arrest. I'll look and see what this one shows. I'm not making any promises here right now. You just got out. And within, 12 days? How many, was it a month? I can't remember.
A month.
You're telling me that you may have used. And
Judge, I believe he was released on the 5th of May.
okay. So 5 weeks. These conditions are to be taken seriously. Anyway, one of the conditions, again, can't use any drugs. Also, you have to show up at all future court dates. When you're on any bond, you have to show up at future court dates. But when you're released on an own recognizance bond, if you fail to appear for for any hearing dates, that's a separate felony you can be prosecuted for and receive an additional 6 to 18 months in prison in addition to whatever happens in this case. So it's obviously important you show up at all future court dates. And when's our sentencing in this case, Mr. Shadow? Wasn't the last one 24th at 10? 9:45. Okay. So your sentencing is July 24th at 10:30. You understand that?
Yes, Your Honor.
So you have to make sure you're here for that. If you fail to appear, that'd be a separate charge you're facing. You understand that?
Yes, Your Honor.
Now, the whole point of this pre-sentence report and the drug and alcohol evaluation that I've ordered is for me to be able to learn more information about you. The way the probation department gets the information they need to make the report is they're going to conduct some interviews with you. They're going to administer some tests. It's important that when you meet with them and talk with them that you're open and honest, because they're going to check and verify everything you tell them. And if they determine you're misleading them in some way, they're going to let me know that, and I'll consider that at sentencing. You understand that?
Yes, Your Honor.
Also, before I'm allowed to even consider probation as an option, even with a joint recommendation, a pre-sentence report has to be completed. Without a pre-sentence report, then I'm not even allowed to consider probation as an option. So what that means is that you need to show up on time when scheduled at the probation department for the purpose of that interview I just talked about. Because if they can't conduct the interview with you because of your lack of cooperating or showing up when you're supposed to, then they can't complete a pre-sentence report. And without a report, the law doesn't even allow me to consider probation as an option. And I won't continue the sentencing to a later day to get the report done because it wasn't completed on time because you didn't show up when you were supposed to. Do you understand that?
Yes, Your Honor.
All right. So you're going to leave here right now. You're going to go to the probation department and meet with them, fill out some paperwork, and get your dates to come back. So make sure Ms. Tuttle will show you where that is or tell you where that is. Make sure you go there right from here, okay?
Okay, Your Honor.
All right. Anything else for the record, Ms. Contour?
Nothing further, Your Honor.
Ms. Tuttle?
No, thank you, Your Honor.
All right, thank you.